Pursuant to Texas Government Code under Section 551.071, the board will meet in consultation with attorney regarding pending litigation, including Weston and Bone versus Round Rock ISD Board of Trustees. So it is 10:54, and we are going to go into closed one last time. Okay, we're going to come back into open session really quick. There was a question of legal counsel regarding who can attend this closed session.
So, Madam President, this part of the agenda is reserved for a closed session consultation with attorney regarding the litigation styled Weston and Bone, generally Weston and Bone versus Round Rock Board of Trustees. I'll ask Trustee Weston, I think, to restate what she asked, and I can respond to that.
I don't have any questions. I expect to participate in all open and closed session meetings. I don't have any questions.
Okay. So because this particular item involves litigation brought by two trustees, the question is whether the remaining 5 defendant trustees in this litigation can ask and compel the 2 plaintiff trustees to not participate in the closed session consultation with attorney on this specific litigation. I've disseminated a 1989 Jim Maddox Attorney General opinion that directly addressed that question. In that case, there was one trustee who had filed a lawsuit against the remaining 6 trustees of a school board, and ultimately the Attorney General opined that it was appropriate for the 6 defendant trustees to ask and compel, if necessary, the one plaintiff trustee to not participate in the closed session because the board has a right to have attorney-client consultation on that litigation, and it would be incongruous with that right to allow the plaintiff in that litigation to participate in that closed session. So this Attorney General opinion, which is, as I said, from 1989, still stands. And that would be the justification you would use to have a consultation with your attorney, just the 5 defendant trustees.
So, Madam President, do you intend to make a matter of public record that Trustee Bone and I are being excluded, even though I'll speak for myself, I am opposed. I do not believe Attorney General opinions do not have, this is not law. Can you just make it clear what's going on here?
Madam President, so Attorney General opinions do carry the force of law and would be recognized in a court of law on an issue if there had been no precedent on this matter. So this does carry the force of law, and you can rely on it for that reason.
Well, this actually cites Texas versus Webster versus Texas as the law, and this opinion actually cites something very unusual at the end. Just above the summary on the second to last page, we caution that this result is limited to the specific facts presented here in this case. So regardless, I'd just like for you to put on the record who you'd like to exclude so that we can get that on the record. And then I'd also like to know if you intend to come back out for another round of item K, if there'd be any action coming out, or any possibility of action.
Okay. So the first, we are asking to exclude trustees Weston and Bone per the AG opinion and per our legal advice. I do not believe we are scheduled to take any action, but I don't know, actually. I know there has been a request from your attorney, and I don't know if we have to take action.
I just wouldn't comment at this time.
So you don't know if you'll take action or not?
It depends.
Okay. So you're asking us, or so we could decline? I mean, we could say, no, we're going to go ahead and go back there. Or is that available to us?
No.
My advice to the board is that there's no way that you can have a consultation with your attorney with the party litigant opponents present for that consultation. We would be prohibited from advising you. We'd have an ethical duty to the district not to do that.
Okay, and Doug, Mr. Ponick, to be clear, your contract with this board is for the entire board. You do not represent individual trustees. I believe the engagement letter says the board. Is that correct? And I am a member of the board.
Right, so let me clarify. So we represent the district through its board of trustees. But when 1 or 2 or 3 board members file a lawsuit against the board, they are filing it against my client. I stand with the client, which is the board. The individuals who sue the board are not my client in that particular litigation.
Point of order. So what's your point? President Weir, I feel like it's very clear that when you take an adversarial position towards the board and sue the board, that you should not be privy to closed session and what happens in closed session. So can we please move this along?
It's actually not, point of order, because it's not clear. That's why there's an AG's opinion. And I think there does need to be clarity in the fact that, you are the board's attorney, which includes all 7 of us, and now you're asking us to not have you as our attorney, and you're not going to represent the whole board. You're actually representing 5, which is the board too. This is a very complex situation. So
I don't want to overcomplicate it. It's an unusual situation. That is indeed true. But I will just reassert that the board is the client, and when 1, 2, or up to 3 members of the board choose to file a lawsuit against the board, they are no longer the client that I'm representing for that particular litigation. I am still representing the board. It is the individual trustees who have initiated the litigation, who have created a conflict of interest for themselves. But as attorney for the board, I still can continue to be the attorney for the board under those circumstances.
I'd like to raise a question of privilege.
Trustee Harrison.
I don't know if that's the appropriate measure, but it seems like they want it on record. Can we go ahead and vote? Or is there a vote necessary? How do we move forward?
Actually, I just need a matter of, let's just say who we're excluding and why. And my other question would be, if I choose to go ahead and enter the closed session, what would happen? Because I choose to, I just want the public to have transparency. But I do object to this, and I do object to some of the things that Mr. Ponick has asserted. And I would just like to understand what would happen if I did walk into the, because at this point you said you've asked, if I did walk into the closed session, what would happen?
Trustee Weston, can I just ask for some clarification? Like, are you saying that you think that you are entitled to hear what our defense is to a lawsuit that you and Trustee Bone have filed against the rest of us, so that you can have privilege to that information in the suit against us? Like, I'm really asking, do you think that you are entitled to that same information when we are not entitled to the information that you're discussing with your attorney?
Yeah, so I'm not prepared to answer that question. All I know is that there is nothing in the law that I have read that would allow for any trustee to be excluded from any open meeting, whether in open session or closed. And so if you're going to go down that path, I would like for it to become a matter of public record. If what you're suggesting is that you will be excluding me from the closed session, please state that you will be excluding me over my objection, and that if I were to enter a meeting that you intend to exclude me from, what you would do if I did that. If we could just get that on the record.
I feel like I raised a point of privilege, and that calls for a vote. So permits an emergency motion dealing with the rights and privileges of the members. I'm asking, can we go ahead and vote?
I'll second it.
Right.
Can I ask a question about the motion?
Well, hold on. I don't know if questions are allowed. I got to find it on my sheet. Maybe I should have clarified the motion. Yeah, which one are you? Oh, raise the question of privilege. it's not debatable, it's not amendable, but it doesn't see Robert's rules newly revised for special rules.
It permits an emergency motion or question dealing with the rights and privileges of its members.
So I can clarify the motion.
Thank you, please.
I move that the 5 board members that have been sued by our 2 colleagues are able to confer with our legal counsel, upholding attorney-client privilege. Does that make sense?
In closed session without the other 2 trustees,
In closed session without the litigants,
the plaintiffs.
plaintiffs. I'm not a lawyer.
Says this motion takes precedence over debate.
Right, yeah, it does say there's no debate. Okay, and it doesn't need a second either, so we will vote on the motion of privilege that was raised by trustee Harrison. All those in favor of trustee Harrison's motion of privilege, raise your hand. All those opposed? Okay, so the motion passes 5-2.